Ebusumo kwaba eroba daily update TV so Attorney General ko TV3 omo Facebook also Attorney General aka assemble Attorney General urges the Supreme Court to strike out suspended Chief Justice request for disclosure of details of petition hearing and allegation of violation of a right. In say Chief Justice FRA interlocutory injunction bia say omo balloting right up in a removal process they should halt it. Na ene on better na samba enra na yura Ayine Attorney General kaze the Supreme Court to strike out suspended Chief Justice request that or appeal in Supreme Court. Rebution may projecting also current update regarding to this issue. Still too.
The Attorney General Ayine has filed a supplementary affidavit rejecting claims by suspended Chief Justice Torkono against the process for her removal. Dr. Ayine wants the court to dismiss those claims. Now, this comes ahead of a Supreme Court hearing in only a matter of hours to hear that injunction application filed by the suspended Chief Justice seeking to halt the impeachment process in its entirety. I'm going to bring in now my producer, Dennis Wedam, who's been looking closely at how the situation has evolved over the last few days, particularly today. And, he'll break it all down for us, help us unpack all the information. Dennis, what are we looking at?
Well, this is actually a quick evolving matter. And just this evening, we are learning that the Attorney General has actually taken a bold step. And this time around, he's not filing an affidavit in opposition to the supplementary affidavit. What he is seeking to do is asking the court to strike out that supplementary affidavit. Now, to put things in context, the Chief Justice is actually challenging this process. She's filed a writ of summons. On that, she's actually filed an application for an injunction. In that, she added her affidavit in support. However, because other events have developed after the filing of that process, she filed another supplementary affidavit in support of that application. Now, it is in that supplementary affidavit that she makes certain comments, which included the fact that she was searched before she got into a place, that dates were fixed without notice to her lawyers, and she deems the whole process being offensive to the procedure that is known, and that the petitioners were unwilling to testify and all that. So that is actually the affidavit in question that the Attorney General wants it struck out. Now, the reason for the Attorney General wanting that to happen is simple. He says that the depositions, that is to say whatever is said in that affidavit, is in violation of Article 1468 of the 1992 Constitution. If you look at what has been said in that affidavit, you would notice that most of the things are things that are purported to have happened during the hearing, which we do know is supposed to be an in-camera hearing. So that's where the Attorney General is coming from. That to the extent that the affidavit, the supplementary affidavit, discloses some of those matters, it is offensive to Article 1468 of the 1992 Constitution, for which reason it should be set aside. But mind you, the Attorney General has actually responded to the main affidavit in support. And that is where you see the Attorney General making arguments as to why the prayer for an interlocutory injunction should not be granted.
Right.
Makes the case why persons like the chairman of the committee, Justice Palman, should not be taken off, why the issues surrounding or raised by the Chief Justice in respect of Justice Asiedu should not be given an endorsement by the courts, and that the entirety of the interlocutory injunction has been prayed for by the Chief Justice should be thrown away. Attorney General has responded to that. However, it is the supplementary, so that needs to be put on record, that it is the supplementary which talks about matters that's related to what she says she went through when she appeared before the committee.
The mental torture.
The mental torture and all those things. The Attorney General has not responded to that. He actually wants it struck out. And the reason for wanting it being struck out is simply that it is offensive to Article 1468 of the 1992 Constitution. So tomorrow, we are in court. The Chief Justice is also expected to be in court, just so that that application will be heard as to whether...
So just clarify for us, which of the applications will be heard tomorrow?
The interlocutory injunction.
The one where she asks that the process be halted?
Yes.
Oh, I see.
But mind you, there's a substantive matter.
Okay.
But because usually the substantive matter will take a longer time, they will add an interlocutory injunction application so that when it is granted, then the process will be halted, and then the substantive suit to be heard, and then we progress from there. But tomorrow, what is going to be heard is whether or not the court would grant that interlocutory injunction. If it is granted, it means that the process will have to be put on hold, at least for now. If it is not, it means the process will still continue as they continue to hear that substantive suit as well.
Tough decision, the Supreme Court would
yes,
have
but they've been here before. And this, like we indicated the last time, will be the fifth attempt, because we've seen 4 other interlocutory injunction applications that have not been successful. This will be the 5th one. We look forward to see whether this will make any difference.
I see. And you know, again, for me, whatever decision happens, because this is the first one that is directly related to the subject matter of the petition. That is the petitioner herself taking the matter to court, seeking an interlocutory injunction.
Yes, so this is the first time the Chief Justice herself is a named applicant plaintiff in this matter.
Indeed.
But in the others, there were other people who went to the court, but for her interest in some ways.
And remember the decision we read from the Otafo MP case.
Yes.
When the argument for those who, the 3-2 decision was that he could not prove that, you know, he was going to suffer directly if the process continues to go on.
Yes.
We will see the Supreme Court tomorrow determine whether or not the Chief Justice would be able to meet that requirement for an interlocutory injunction.
That's an interesting one. And those are matters that are largely within the remit of the Supreme Court to determine tomorrow. I mean, tomorrow is not too far from now, so we look forward to that particular.
I really can't wait. It will be a very interesting day tomorrow. But thank you so much for bringing us all of this. Let's bring in now legal practitioner Martin Pebu. Lawyer, thank you so much for joining us here. But let's start out from the very latest, because the supplementary affidavit that the now suspended Chief Justice filed is in violation of Article 1468. What do you make of that move that the Attorney General has just made?
It would be extremely useful, right? Extremely useful because, you know, in about, it's not less than 15 years ago. Yeah. Not less than 15. Actually, yeah, almost close to 20 years. About 20 years ago, in 2005, 2006.
Counsel, it would appear you're ahead of me. I was asking about, Dr. Dominic Ayine, he himself also filing his own supplementary affidavit seeking that the supplementary one that the Chief Justice, a lot of supplementary affidavits that as Chief Justice had filed about, that torture she had gone through, be struck out. So my question now is, how does this latest move by the Attorney General come to you, given the context that Dennis has just provided us?
It's normal within Ghana, okay, within our legal system, within our justice system. These kind of applications, they are normal. Yes, we've been doing this for a long while. I'm not surprised at all. No, this shouldn't spook anybody. I'm not surprised. It's also within the rules. It's allowed that if one party is of the opinion that the other parties, the positions, etc., are scandalous, they are frivolous, they are vexatious, etc. Those are the words in our rules books. That person who feels offended can apply that those provisions be struck out. So allow the Attorney General to also exercise his rights, just like I had said earlier on that the things that the Chief Justice has stated, these very things that the Attorney General wants to strike out. I was saying that to the extent I've not yet heard the Attorney General's response, we shouldn't begin to comment too much on what the Chief Justice has said, because we have to hear the AG's response before we know what to say. If you haven't heard the other side, you may rush and make some comments that later you'll find out that it would have been wiser to wait. So let's reserve judgment. So the Attorney General may go ahead with his application. Yes, the Supreme Court will rule, and that will guide all of us.
Indeed. And there's no denying that tomorrow is going to be a very significant day as far as that hearing, the interlocutory injunction hearing is concerned. But Council, hold on for me, because we also know that the Majority Leader, Mahama Ayariga, has been making some revelations on the floor of Parliament. According to Ayariga, government is getting ready to introduce new legislation to smoothen the process for removal of Supreme Court justices, including the Chief Justice. Take a listen. All right, we'll bring you that sound clip or video clip later. But right now, let's look at it in words. A few things that he mentions: Legal Aid Commission regulations, Supreme Court rules, removal from office of justices of the Supreme Court. Listen, essentially, forget about that. Essentially, what he's been telling us is that the government is looking at new legislation to ensure that what appears to be a rather complex, cumbersome process of removing justices of the Supreme Court, as you already know, one injunction after the other, one concern about the process going through the court back and forth. Some have described that as an abuse of the court. What he has told us on the floor of Parliament is that the government of the day is preparing to review the Constitution and introduce new legislation to allow for a more smoother, more direct process that will prevent and avoid all of these bottlenecks associated with the removal of a justice of the Supreme Court. And that's what he's been saying on the floor of Parliament. So I'm going to bring back Martin now. Martin, you had a summary of what the Majority Leader, very significant member of this government, if you look at it in the space of things in Parliament, he is the leader of government business, as they are called. He is making this statement, and obviously coming from him will be considered very significant. So here's my question: to what extent is this admission an objective to review the process useful?
It would be extremely useful, right? Extremely useful because, in about, it's not less than 15 years ago. Yeah. Not less than 15. Actually, yeah, almost close to 20 years. Yeah. To about 20 years ago, in 2005, 2006, there was the case of Frankie J. Chum versus Attorney General, where some persons, J. Chum presented a petition for the removal of the Chief Justice, etc., right? And then, so long story short, the part that concerns your question is that the Supreme Court itself saw that Article 146 was too skeletal. Naturally, we couldn't have written the whole code for the removal process into the Constitution. So the Supreme Court made a call that the Rules of Court Committee, when we say Rules of Court Committee, it's also in the Constitution. It's provided in the Constitution that when we want to make rules for the functioning of courts, etc., same should be done by the Rules of Court Committee.
Council, I apologize to interfere with your thought pattern again, but I have to take a much-needed break. When we come back, we'll look at this issue and whether or not, listen, the same government that is saying that we want to follow the process is also faulting the process and saying that perhaps we should review it, whether or not it appears counterproductive at this time, and what processes they would follow to be able to do this. And again, a question of if it can have a retroactive, effect with regards to the removal of Chief Justice Torkono. Don't go away. We'll be right back.
Of this can be finished within this very term. Though Mama Yaga has expressed the conviction, but remember that we have not seen the rules. So, and I've not seen any advert anywhere about stakeholder consultation. So remember that Godfrey Dami says in the previous administration, they were left with stakeholder consultation. So it means that this government will have to go through the same. Apart from stakeholder consultation, and let's not rush it. Look, the people in government alone don't have all the knowledge in the world. So at a point, this document will have to be shared so that other lawyers will also weigh in. So we don't need to rush it. We don't need to. So it must go through a public debate, kind of stakeholder consultation for citizens to weigh in before it's laid. And even in Parliament itself, before they lay, they have the pre-laying procedure, which even though not expressly provided in the Constitution, sometimes at the pre-laying stage, the other members of the Constitutional and Legal Affairs Committee also make inputs. And sometimes even during the pre-laying consultation, based on what they raise, you even find out that the CI or LI has to be taken back. So it's not laid. So usually they don't lay it automatically for the 21 sitting days to start counting. No, there is a pre-laying that has to be done with the committee. And the committee will also make their own input. So the key thing is that it's good that Majority Leader Mama Ega says they want to pass it. But the first thing is that make the document public. You see, make it public, let's weigh it. Then from there, they will do the pre-laying before the actual laying for the 21 sitting days to kick in. And by the Constitution, after the 21 sitting days, if nothing is done to shoot it down by 2/3 majority, then the CI will pass into law.
Very well, Council.
So for me, it looks long. It's not something that can be done in 1 or 2 months. No.
I see.
By the time the public finish commenting, you see the kind of changes that they may have to make to the document.
Very well, Council. Leave it here. We'll continue another time. Thank you so much for your insight on the subject matter. But let's turn attention to our power sector now, because new revelations around ECG's logistics scandal has raised new crucial questions. Ongoing investigations have uncovered nearly 2,500